So this is the last roundtable and forces, so we won't be talking about stochastic equations, or maybe Andrea could, but I certainly couldn't. So the topic of this last roundtable is for each agency to be able to say what are the implications of algorithm and digital issues in their agencies today. As you know, we are in a very active debate on all our different countries. The topic of digital is of great interest, not only for academics and practitioners, but also for politicians, members of parliament, and they want to do things. And I think that Konrad will be able to tell us about what is happening in Germany right now, and the project of a new law adapting the current competition law to take into account the digital. Andrea will be able to tell us also about the follow-up on the Furman report, I imagine, and what the CMA has been doing very actively on those topics, and including a very interesting study about price comparison tools that has been very interesting, and it's a very current type of algorithm that are being used. And Gabriela will finish by telling us maybe about what is going on also about the project that they led with other agencies. And we have not mentioned it before, but algorithms are really one of the topics in which I think competition agencies must engage with other regulators. Privacy, but depending on the countries, the issues of ethics on algorithm can also be of great interest for us. And with other regulators, we share the need to understand how algorithm works. So that's also an area where inter-agency cooperation can be really useful. So I will start by giving the floor to Konrad, maybe to give us the German perspective.
Thank you very much, Isabel. For me, it's a great pleasure to be here. Andreas Mund asked me to say again, to transmit again his apologies for not being here, but well, it's for me the pleasure to be here, so thank you very much. First of all, I would just wanted to stress again what Andreas already stated in his video message. I'm very pleased that we could conduct our joint study, our conceptual study on this very important topic, and I think the roundtables today showed how interesting and how many aspects this topic has. We had this experience before in our study on big data, and now we have this algorithms project. And I'm sure it's not the last joint piece we are working on. This paper is just one piece of the puzzle of addressing the challenges posed by digitalization. Within the debate today, the strong focus was on collusion, the potential of the algorithms to support collusion or to autonomously collude. But we, of course, have to keep in mind the potential interrelation or interdependency between algorithms and market power. Market power of companies that use these algorithms. In this study, you will find a chapter on this relation, and of course, this relates as well to the potential adaptations of our box of possible instruments, how to deal with these new challenges of the digital world. So, as Isabel has said, some thoughts of our coming reform of the German Competition Act. Taking into account the practical experiences and recommendations from research and these many reports out there in the world, many legislators think at the very moment of how to adapt their law. It's not only in Germany, it's in many other countries. I think Andrea will speak about that as well. While considering that, we had the impetus in Germany as well on other things. We had to reform the law, but in Germany at the moment there are pretty concrete ideas on how to adapt our legal framework, specifically in the area of abuse control. And what is the aim? Of course, we should act earlier, quicker, and even more effective. Our Ministry of Economic Affairs is about to publish a draft bill for the next reform of our German of our Competition Act. An early version was already published privately on the internet by a professor. It's an earlier version, but well, we expect that our ministry will publish an official draft pretty soon. I will just touch on a few aspects that are currently included in the draft document. On the one hand, our traditional rules will be enhanced. You may know that in Germany we have a rule which already allows at the very moment to intervene in the markets below the dominance threshold in specific cases. I think in France you have as well some areas where you don't need to establish dominance. One idea in the draft is to broaden the scope of this rule and to clarify the conditions under which there can be dependence on multi-sided platforms which would allow already an intervention. In this context, there might also be some clarifications on the eminent role of data and amendments that facilitate access to data. On the other hand, there's a specific proposal to go really beyond traditional rules, in particular to address conduct of certain types of powerful platforms. And in these many discussions we had on this issue of addressee of abuse control, we have often the thought, well, whom do we want to address? Somehow you know it when you see it, but it's difficult to describe. Some speak of platforms of systemic relevance. Others say, well, they have to be active on several interrelated markets and have something like a strategic market status. That was, as a Furman report put it, or platforms on which other companies are dependent to a large extent. Platforms making the rules for business between others, acting as regulators, as the special advisors to Commissioner Vestager called it, for players who have the power and resources to expand their activities into new markets. Sometimes this phenomenon is called envelopment. To be more precise on the German law, the current proposal is meant to address abusive conduct of undertakings of paramount significance for competition beyond the scope of one market. This is the kind of definition of the addressee. The underlying idea is that the Bundeskartellamt may issue an order stating not more than that a certain company is of such significance. So the first step would be really to state, well, this company is of paramount significance for competition beyond the scope of one market. You see there's a certain, the traditional bond between dominance and a specific market is somehow a little bit relaxed. This could result from something like super dominance, if you have a dominant position in several independent markets, but it could also be driven by further factors such as access to relevant resources, a strong degree of integration, or a gatekeeper function. So for such companies, the Bundeskartellamt may issue specific prohibitions, and it's important to say it's not a per se prohibition, but the authority can issue specific prohibitions addressing self-preferencing, envelopment strategies, certain cross-market data processing that impedes competition, limitations of data portability or interoperability, or inadequate behavior in specific situations of asymmetric information. You see, once this rule becomes law, the delineation between competition law as you have it in the classical sphere and regulation becomes a little bit blurred. And rightly so, I think. If you want to tackle the massive economic power of the tech giants, I think it's at least from a conceptual point of view important to think further than traditional competition law. Of course, there will be room for objective justifications, but then the burden of proof will be shifted to the respective company. Well, the discussion on the proposal will start, or just started, because it's now in the public sphere, and it's obvious that the conduct addressed by these proposals is likely to be connected with the use of algorithms, our topic of today. Just think of the algorithm-driven self-preferencing of the Google Shopping case, or the concerns voiced about Amazon's buy box and the use of competitively sensitive information, or algorithms to facilitate data portability, or interfaces to establish interoperability. So this shows that it makes a lot of sense to continue expanding our expertise on algorithms. The challenge will be to further improve our ability to assess potentially complex business strategies that involve the use of these algorithms. And I'm sure our paper will help a little bit at least. Thank you very much.
Thank you very much, Conrad. It's interesting to see on those proposals that there is this new trend in terms of defining a certain category of companies that then may be subject to specific obligations, a little bit like we have seen in the Furman report, and the idea that we pick up some companies in advance, even before an actual case. So that's that can be quite different from what we had in the past, where we would assess dominance in a specific market and for a specific case inquiry. So Andrea, what are your views on the topic?
So thanks, Isabel, and thanks for organizing this very interesting event. So, I mean, first of all, I think it's important to just step back a second. In a sense, if you think about the discussion this morning, which I think has been very interesting, I mean, why are we very interested in a topic as competition authorities? I mean, the concern is obviously that the outcomes for consumers are not good in some sectors because of the way algorithms operate in the particular sector. And in many ways, while the academic discussion today is about various categories, and we might worry about autonomous behavior or explicit collusion of some sort, the reality is for consumers this is hidden. I mean, consumers don't particularly care about it, but they care if the fuel prices go up, if the prices of airline tickets go up, and that in many ways is what worries us. So again, it's, to me, while it's very interesting to understand and think about the different categories, or trying to think whether is competition law sufficient, do we need to do more regulation? I mean, at the end of the day, what matters is the concern we have that we're sitting here, and while all of this innovation goes on and there's clearly a lot of efficiency, and we're very happy to see that sometimes we're missing something, and we're missing something either because there is a grand design by some companies that we just undetect, or whether because of the way autonomous behaviors operate, the prices increase. So I think for me this is something that is going to move in various ways over a number of years, and our role is very much to monitor, to understand, to think, and then potentially to react to that. So what are we doing as a CMA? So first of all, we are sort of investing in our own knowledge. I mean, this is clearly an area where there is a very significant asymmetry of information between regulatory authorities and companies, as we've seen today as well. So we have set up a data unit, which is now around 20 people, and we've hired a number of data scientists and data technologists to help our own understanding and certainly help us interact with, for instance, some of the academics here. I've already interacted with some of my colleagues. And it's just very important for us to tap into the knowledge and expertise that is out there. And it's very much work in progress. I mean, we are, I think, at the very beginning of the road on that. Secondly, we obviously learn from some cases. So as algorithms become more prevalent, we encounter some of these issues more and more in our case portfolio. And obviously, there is an element of internal R&D from actually doing the cases and reading the documents and talking to the experts, which is very helpful. So, for instance, we had 3 years ago an explicit cartel, which was implemented through repricing software on Amazon. This was a case that we did in conjunction with our colleagues in the US at the Department of Justice. It was about online posters and frames. In itself was a small cartel, but what was interesting is that there was explicit communication between the cartelists, but also they were using these software and talking to one another to make sure that the software was preventing the sort of the price wars between them. A couple of months ago, we had an infringement decision on, again, a fairly standard resale price maintenance case in musical instruments. This was on keyboards and digital pianos. The company was Casio, the Japanese company. And what we found was that for a number of years, they used very sophisticated software to monitor what all the retailers were doing. And that was combined with very standard sort of threats to the retailers not to discount below the recommended prices. So that in many ways, again, it was a standard case, but again, what we have seen is the use of sophisticated software to make it easier in this case for the strategy. And the European Commission obviously had similar cases in 2018 in this area. The area that where we haven't had an explicit case, but which worries us is, and was touched upon a bit today, is the sort of some of these companies that are offering these services to third parties, particularly on Amazon marketplaces and other places, where if you go and look at their websites, they have these very interesting logos. You know, this is the best way to avoid any price wars with your competitors. So there are a number of things that you can imagine. Certainly, they haven't spent a huge amount of money talking to competition lawyers before finalizing their websites. This is not to say that necessarily it's a problematic activity, but it's certainly worth us and others looking into it. And again, this is to me one of those areas where continuous monitoring is needed. It's very case specific. Are these companies being used by the other company to exchange confidentially sensitive information? Is there illegal information exchange taking place? So there are a number of specific questions within current sort of case law principles that are certainly worth investigating on specific cases. Then we, some of this comes up sometimes in merger control. Obviously, we do merger control the way we have done it for many years, but then what you learn sometimes from internal documents is that there are very sophisticated algorithms setting prices, again, in situations like fuel, retail, and this is clearly part of the assessment for us. And obviously, there is potentially a concern in industries that are quite concentrated, whether if you increase the level of concentration, whether some of these possible concerns about collusion, tacit collusion or parallelism of some sort would increase, and whether that potentially is a reason to prohibit the transaction. So for instance, we blocked a retail merger earlier this year in the UK, Sainsbury and Asda, which are two of the four key players, and the merger was blocked for a number of reasons. But one of the markets we worried about was fuel, because these were two of the key players in the market. And what we saw from the internal documents was that they were both themselves and the other key players were using very sophisticated algorithms, and a lot of the price wars or a lot of the kind of cycles where the algorithms were going price down were initiated by these companies rather than others, and that was one of the considerations for us in the overall assessment. Obviously, on abuse of dominance, Conrad mentioned the Google Shopping case, and again, that's in many ways it's a traditional approach in terms of the case, but again, the self-preferencing and the ranking was very much part of the assessment. And finally, on cases, we obviously are also a consumer protection authority like Gabriella's, and quite a lot of our work is in digital space. And for instance, we did some work on online travel platforms, which again was very much looking at the ranking algorithms, and some of the concerns we had were about, for instance, the use of commissions, which was not disclosed to consumers, and then some of the misleading claims about scarcity or discounts that the operators agreed to change following our intervention. So we do cases and we do market studies, like Isabel mentioned, on digital comparison tools. We're doing currently one on digital platforms funded by advertising, which again is very important in itself, but also in terms of us understanding how a number of these markets operate. And then quickly, in terms of the overall strategy, so while we are doing cases, we are also thinking about, I would say, continuous improvements to our processes. So we went public a few months ago with some changes we would like to see in legislation in terms of our powers, so very much along the lines of what Konrad has mentioned for Germany. And these were about a number of areas that are relevant for the discussion today. So one, for instance, is information gathering powers. And again, it's quite interesting for us having now the technologists in the office and the way they think about auditing algorithms or understanding how algorithms work and trying to apply that knowledge to the strict legal powers we have. And we realize there are some areas where potentially there are some gaps that we want to fix. And on the consumer powers, which is very important in this area, we don't have fining powers, which we think is a significant problem in terms of deterrence. So that's something we have asked for, and hopefully we will get. And then on the antitrust side, similarly to other agencies, we like to use interim measures more often. And again, there are some changes to procedures they would like to see. And also we have sort of an ongoing discussion with our parliament, and our future parliament coming out of the elections will be on the kind of judicial review process and the way the end-to-end of antitrust cases operate, because I think timing is really a problem in general in the digital space, and particularly in this area, the fact that it just takes too long for these cases, particularly when they are litigated. And then finally, again, I'm very much in the same place as Konrad. I see some smart dynamic regulation as a complement to competition law in this space, and the question is exactly what to do. I think Jason Furman and his academic colleagues have published a very good report that we very much support, and we just hope to see implemented over the next months by the UK Parliament. And again, there the idea is to identify, I think, some areas, some core problems where some smart ex-ante set of rules can actually complement the ex-post enforcement to just create a better balance between small and medium-sized businesses and some of the platforms, and also between consumers and businesses. And then finally, I think, as Isabel said and as indicated today, I think international cooperation is critical in this area. If I look at our current market study on digital advertising and digital platforms, there's probably one of 6 or 7 or 8 similar initiatives in Europe, in Australia, in the US. And if you think about the problems we're trying to solve, some of these issues are generally global. And there is an issue, while on merger control, I think competition authorities have been very successful over the last 10 or 15 years to integrate global interventions. If you think about cases like Bayer Monsanto or Dow DuPont, we're not there in the same place in terms of enforcement, and I think that's really one of the challenges for all of us going forward. Thank you.
Thank you very much, Andrea. Now I will leave the floor to Gabriela.
Thank you, Isabelle, and I would like to thank l'Autorité de la Concurrence and the Bundeskartellamt for the publication of the study, the organization of the conference, and the invitation to the Italian Competition Authority to take part in this panel. The competitive landscape in the digital economy is increasingly changing due to the combination of big data with highly advanced IT tools, and such as pricing algorithm, machine learning, which enable large volumes of data to be acquired and processed quickly and efficiently. There is a growing number of firms using computer algorithms to improve their pricing models, customize services, and predict market trends, which could generate efficiencies. On the demand side, comparison tools and electronic marketplaces allow consumers to quickly compare prices and other conditions of products and services across a large number of online sellers. And this facilitates consumer choice and leads firms to compete more aggressively on prices. On the supply side, rational companies would naturally exploit the same degree of price transparency to identify the best positioning of their offer on the market. However, at the same time, pricing algorithms might lead to increased individual-based price discrimination, insofar as companies can collect and analyze a broad range of information revealing the willingness of individual online shoppers to pay. While fostering increasing competition, a high degree of price transparency and the extensive use of pricing algorithms in online marketplace may also raise competition concerns. Pricing algorithms may increase the ability and incentives of companies to reach, monitor, and enforce both explicit and tacit collusion, and may also enable exclusionary and exploitative abuses of market power. The Italian Competition Authority has analyzed competition issues related to algorithms in its sector inquiry on big data, carried out with the Italian TLC regulator and the Italian Authority for the Protection of Personal Data. At the beginning of July, the three authorities published the guidelines and the policy recommendations which conclude the inquiry, and the full report will be released soon. For now, I can say that the authority has assessed algorithm as an element that contributes to strengthening market power, and in turn as an enabling factor for the abuse of market dominance, whether they be exclusionary or exploitative abuses. Moreover, the authority analyzed how algorithms can facilitate collusive behaviors. As a result of these assessments, the authority has made one of its priorities, its policy 7 of the guidelines, the detection and deterrence of abusive behavior by the key players in the digital economy, and the fight against cartels and collusive behavior, both of which are facilitated by the development of new software and advanced algorithms. As for the cases, the Italian Competition Authority has recently launched a case against Amazon, which may involve algorithms. According to the authority, Amazon, through its algorithm, allegedly discriminated on its e-commerce platform in favor of third-party merchants who use Amazon's logistics services, exclusively use Amazon's logistics services. In particular, Amazon allegedly granted improved visibility of the seller's offerings, higher search rankings, and better access to consumers on Amazon.com only to third-party sellers that subscribe to Amazon Logistics or Fulfillment by Amazon, FBA. In such a way, Amazon could, this is a self-preferencing case. In such a way, Amazon could unduly exploit its dominant position on the market for e-commerce intermediary services platforms in order to significantly restrict competition in the e-commerce logistic market, as well as potentially in the e-commerce platform market to the detriment of final consumers. The Italian Competition Authority has a two-fold competence in both the enforcement of competition law and consumer protection law. This allows the authority to address issues relating to the digital activity of large operators by leveraging the most appropriate tool to better address them. The positive effects of algorithms for consumers and for competition depend on the extent to which consumers are provided with transparent and trustworthy information, and might thus be undermined by unfair practices that can distort consumer choice. So far, the Italian Competition Authority has found several unfair practices that were employed through online comparison tools and the relative underlying algorithm. I only mentioned a case before close my statement. In August 2017, the Italian Competition Authority imposed a 5 million euros fine on Trenitalia, Italy's main rail passenger transport operator, for neglecting regional trains in its travel options on its corporate website and in its algorithm. The algorithm steered consumers towards more expensive travel solutions, high-speed and intercity train options, without informing them that the results displayed did not include all the options available. And I stop here by now, and thank you for your attention.
Thank you, Gabriela. So you already have some very recent cases and other cases ongoing that are really very directly related to algorithm. Maybe you would like to comment on the current legal framework. You think it's working, or do we need to invent new theory of harms, or do we need new tools to tackle algorithm?
Thank you, Isabel. As I've already mentioned, the online giants who are becoming more dominant business models characterized by services apparently offered free to consumers in exchange for data and attention, and advertiser which subsidize free services in exchange for the possibility to target consumers with advertising. They are becoming dominant in different sectors. And with the advent of these new business models, the consumer welfare approach has been very severely criticized. And several scholars have observed that the consumer welfare principle is excessively based on economics. As you know, this new approach has been renamed as the neo-Brandesian or hipster antitrust, and the Italian Competition Authority has been accused several times to be very hipster. And in this context, no price parameters such as quality and data protection may become very relevant for the competitive process. And building such a theory of harms have raised some challenges to the competition authority, especially with regard to the definition of the relevant market, to the rethinking of market power. Just think of the using of the small but significant, no transitory decrease in quality test. And also, algorithms may raise competition concerns, especially when assessing collusive practices, as already mentioned. We refer to, very often, the term algorithm is used improperly. When we imagine the cartels of the future, we are not talking, in fact, about a simple algorithm, which is in itself a neutral instrument, but rather we refer to much more specific techniques for implementing the artificial intelligence that has been mentioned today. And we are talking about the machine learning algorithm, or better still, the deep learning. And algorithms change certain structural characteristics of the markets, such as transparency, frequency, and frequency of interaction, and so on. As a result, they increase the likelihood of collusion. You have already mentioned the importance of cooperation, coordination at the international level, so I will not come back to this point. And I think I can close the second part of my statement. Thank you.
Thank you, Gabriela. So I will now share my views on the topic, and this will be my final words on the conference, and then I will open the floor for some questions. So what can we conclude based on the study? The actual study, as I said before, will be available online, but you will be able to have an executive summary when you will be leaving the conference. Maybe I would like to point out for practitioners lawyers or representatives from company, the final part of the study, which describes in a very concrete way the type of questions that an enforcer might ask to a given company if they are investigating an algorithm. So those are really, in a way, simple questions to ask, maybe not so simple to answer. For example, when was the algorithm created? What was its objective? How did it change over time? What type of data did you put into this algorithm? So we really have a sort of checklist of questions that we might ask to better understand the way an algorithm functions. But I think that one of the things that we saw and discussed earlier today is that it's not necessarily so simple to have the answer to those questions. And what I think maybe one of the main messages I would like to put forward today is the issue of accountability. The word explainability has been mentioned in the earlier roundtable, and I think that those two notions are closely related. Because I think that given the importance that algorithms have in the economic life, but also in society, we need to change the way they are being designed and discussed. I would like to give back to an example that for me is really interesting. I was mentioning earlier this algorithm APB, and there was really a huge debate in France about the way this algorithm was working, the way it was sending students in different universities or not giving them any slot because the algorithm was answering no, we have nothing for you. And this is really an example of algorithm that is of vital importance for those young students waiting to have a slot or not in the university of their choice. And what was interesting was the debate about finally how does it work, this algorithm, and how was it designed. And when research were done about how this algorithm had been designed, really it was not clear. There was not a general discussion about really what were the objectives and the main criteria that would be decisive for the outcome. And after this crisis of this algorithm that was changed by tweaking the way it was working, there was really the idea that there would be a high-level commission with members from the ministry and all type of people that needed to get together with the IT people to discuss on what were the criteria, how the objectives, and to try to predict the potential side effects, negative side effects. So I think that it's interesting in terms of process to see that those choices are really extremely important. It's not always possible to predict how the algorithm will work and if there will be a shortage of places, for example, because this is a matching algorithm. I would like to compare this with what we have heard about algorithm in the business life of companies. We have seen with the example of the airline industry or retail industry with Carrefour, how algorithms are really critical to keep your client, to sell your product or your service. So this is really the bread and butter of everyday company life. Many algorithms, they not necessarily have a competition risk, but they are critical, and they may have a competition effect on the way companies compete on the market. So I think that the examples that were given about whether they are or not black box algorithm are really interesting, because an algorithm might be black box for a given company or individual, but might be explainable for another company with a deeper knowledge of this type of algorithm. So I can really underline once more what I was saying earlier, that when we discuss with given companies such as Google, Amazon, or Facebook about the way their algorithm works, it's not always easy to have the right answer about how this algorithm is working. Also because within the company, maybe not everyone has the knowledge or is able to explain or willing to explain how the algorithm works. And we are seeing with the debate about other type of algorithm like social networks, social media, and the debate about fake news, conspiracy theory, does the algorithm favor fake news or conspiracy theory, that this has really become a real debate about society issue and even on a broader remit than only competition. So this is really a message about accountability. Maybe on the point of view of the law, what we find in our study is that the current legal framework is really functioning very well for most collusion cases. Article 101 can be applied without major difficulty, but, and this has been underlined before, there is a debate about whether we should expand the scope of Article 101 to apply to parallel behavior and new forms of coordination. Should those behaviors fall into the scope of Article 101 renewed or reconsidered? So that's one, we don't give an answer, but we underline this topic. Another issue that is clearly underlined in the paper is that there is a big issue between the algorithm per se and the data. An algorithm in itself might not be so problematic, but if the data that is being put into the algorithm is critical and not accessible to other parties, there might be a competitive element that will be interesting. And this is, of course, in relation with the debate about new ex-ante regulation about access to data. Another note about Article 102, because when we talk about algorithm, we often think we often discuss a lot about collusion, but I think that there are some very new and interesting issues from the point of view of abuse of dominance, and of course, one of the reference cases that we have today about algorithm is the Google Shopping case, which is an abuse case. So in the study, we underline the type of cases that might lead to an abuse. For example, refusal to supply access or information relating to specific algorithm. Maybe an algorithm applying excessive prices. Also, in certain cases, an algorithm performing individual pricing or price discrimination, or maybe self-preference, like this has been mentioned in the ongoing Amazon case. And also the case of ranking algorithm that may also lead to a debate about self-preferencing. So those are really examples of the type of cases that might be looked at from the point of view of competition agency. Maybe on a final note, I would like to say a word about the question of competition enforcement on the one hand and ex-ante regulation on the other hand. In fact, we already have a recent regulation that is quite in relation with our topic. That's the platform to business regulation that has been recently adopted. Because to give you an example, one of the articles of this regulation applies to algorithm, because it lays down the principle that ranking transparency requirement must be applied by online intermediation services and providers of online search engines. So we have this rule now at the European level, and this rule is really inspired by a French law that had been promoted a few years ago in the law to promote the digital republic, that also had this idea of transparency. So we see the legislator moving forward in certain cases to impose transparency. But this should not be a general principle, because from the point of view of competition, transparency is not always positive for competition. So I think that we need to be quite careful to define the good areas where we need to regulate, and like Andrea was saying, this should be seen in complement to other forms of competition enforcement that leave the market regulate itself. So before maybe opening the floor for questions, I would like to underline that this paper is not the end of the matter. Of course, it's a beginning. We really are looking forward to having feedback from all stakeholders about this paper that raises many questions and does not want to provide definitive answers. Did we point to the right challenges? Did we forget some challenges that might be put forward? And I would like to finish maybe by saying a huge thank you to the many people in the room that have contributed to writing this paper. I think that we have almost all the contributors, so a huge thank you to them, because it's not always been easy to work from Paris to Bonn through email, telephone calls, and different things to because each and every word of this paper has been discussed and written with several hands. So thank you again to everyone. I will now open the floor to some final questions before we adjourn to the cocktail. Une question là.
Merci. Pardon? D'accord. Merci. Thank you very much to all the speakers for the presentations. They were very interesting this morning. I have a specific question for Mr. Ost. And for on the new piece of legislation that is contemplated in Germany, I'm not sure to have understood the new prohibition or power of injunction that the Bundeskartellamt would be entrusted with concerning multi-market companies. Would the Bundeskartellamt define these companies or determine a list of companies that would be subject to these new rules so that they are all aware that they will be subject to this threat from the Bundeskartellamt? Or how will you give some legal certainty or security to these companies so that they are aware of this new legislation applicable to them?
Yes, thank you for the question. Yes, it's as far as I understand the draft, it's a two-step approach, but both steps can be done at the same time. So the first step from the theory is to order that a company is fulfilling this. How is it called? This is a strategic. What is the paramount significance for competition beyond the scope of one market? So it's to be addressee of this new paragraph. So that's the first step. And there are kind of several criterias, and these are not the classical criterias for dominance, but other criterias. And then obviously that's something by law, and we try to apply the law, and then the courts will have their say. So then there you have the addressee. At the same time or afterwards, well, it can be both, the Bundeskartellamt may make use against these companies power of their prohibition powers, which are stated in the second paragraph, which, for example, one of the most most famous thing is maybe self-preferencing. You can prohibit self-preferencing, but for the future. It's not that if you infringe in the past that you're liable for damages or something, but it's for the future. So that's how it works, at least as far as I understand the draft. It's possible that you combine both. That in a proceeding you first in the first part of the decision you define that they're undertaking as the addressee, and in the second part of the decision you prohibit something, but for the future.
So, a little bit of common inspiration with the Furman report, but with a different way of. It's not the code of conduct, but similar inspiration. Maybe two last questions, very, very quick.
Yes, hi. Pierre Kirk, avocat. I have a question that is inspired by Mr. Koschelli's remark concerning the creation of the digital unit within the CMA. This is a subject that fascinates me. It's the use of data in the other direction, I guess you would say. Particularly in merger control cases now, beyond the legal requirements to supply in-house reports and so on and so forth directed at board of directors and so on and so forth, we see more and more often what I would call document requests, which concern categories of documents, oftentimes emails, all emails on such and such a subject within such and such a time period, which can entail vast quantities of data addressed to the relevant authority. Here's my question: what technology is used by the authorities in order to deal with this vast amount of data. I think, as a representative of companies, that it's a valid question because time is money, and oftentimes these data requests come in pre-notification and can make pre-notification last quite long, months even. And so the question is, how do the authorities deal with data?
So it's an excellent question. In many ways, it's a very salient discussion we're having internally. So I think where we are, and I think the European Commission is in a very similar place. The American agencies, as you know, have been taking in lots of documents and emails for quite some time, is that there is a clear benefit to particularly complicated in-depth assessments of mergers to have access to internal documents and emails, because unfortunately in a number of cases the kind of the submissions from the parties are quite orthogonal to what the internal documents are when one looks at them. So it is quite important for us to have access to it. At the same time, I completely agree with you that there is a risk that we cause lots of cost to companies and we collect lots of evidence we don't use, which clearly is not a good place for us to be in. So one of the key projects this unit is currently doing is to think about our current system. So at the moment, we have sophisticated software like law firms and professional services firms. We load all the evidence we get into the software, and the software is used for a systematic assessment of the evidence. As most people here who work in law firms and professional services firms know, this is a field that keeps changing. So there, we use a particular provider, there are other providers, there are new versions of the software we are using. So we're constantly looking at the marketplace and looking at what is available in our own processes and to try to become as efficient as we can be. Because clearly, not only there is a risk about cost, but there is also a risk in terms of litigation for us and for the companies in terms of collecting evidence and not using it systematically. So it is really, I can assure you, one of the key things we're spending time on.
I don't see any more questions, so maybe Conrad, you want the final word?
Yeah, thank you very much. I think this conference was really inspiring. When you leave a conference with more questions than you came up with, it was an excellent conference. And the one thing I learned from this conference is that algorithms seem to be very much like humans. They can be subject of behavioral economics because you have to study their behavior. You don't know in advance. Algorithms collide and collude. And some prognosis is that they are more colliding than colluding. They are rogue algorithms, like rogue employees, but maybe this phenomenon is as rare as the rogue employee, because we very rarely see rogue employees. But well, it's interesting to see that you see that for algorithms as well. And then we see the prospect that you have to educate algorithms that they abide the law somehow by certification, or it's a kind of educational process for algorithms. Very, very interesting to see. So this is a brave new world, but our business people told us, well, there's much more human influence than we thought. In the end, most decisions at the moment are still done by humans. So that's kind of interesting to see. But of course, we will see the development, and it's a fascinating development how it's going to be. Well, this is the moment for me to thank our host. Merci beaucoup, Isabelle, for hosting the conference, for the whole team, to organizing this, and even more for the long cooperation we have with our authorities. It's good to see that the French-German, not coalition, but l'amitié franco-allemande is working. So thank you very much.
Thank you, Conrad. So there is a word we didn't say yet. It's compliance by design, but you will find it in the study. Just to say that we will discuss, of course, on a case-by-case basis, but clearly companies should look into their algorithm engage in discussions between the legal department and the IT department. So that is one clear message that you can take away with you. And I wish you all a very good day, and thank you again for all the team that made this possible and wrote this excellent study. Thank you.